Article 1 of the U.S. Constitution grants Congress the exclusive power to legislate, a fundamental safeguard to prevent the concentration of power in any one branch of government or unelected bureaucrats. The recent Supreme Court decision in Loper Bright Enterprises versus Raimondo marks a critical turning point, reinforcing the principle that courts should not defer to federal agencies when interpreting the law. This ruling is a vital step in restoring the constitutional balance of power, protecting the due process rights of our citizens, and ensuring that unelected bureaucrats no longer have unchecked authority to shape and define statutory policy at the expense of the American people and contrary to congressional intent. This decision, however, also serves as a plea to Congress to write better laws. For far too long, this legislative body has taken the easy way out, writing vague and ambiguous laws riddled with undefined terms and broad authorities. We must do better. Today, we are examining two far-reaching and consequential laws, the Endangered Species Act, or ESA, and the Marine Mammal Protection Act, or MMPA, both of which have been administratively defined and redefined so many times that their original authors would be hard-pressed to recognize their original creations. While my home state of Wyoming is not directly impacted by the MMPA, this law impacts industries that are important to all Americans, not just the coastal states. These include our fishing industry, ports, maritime transportation, and offshore energy development. When MMPA was first enacted in 1972, it was 20 pages long. The NOAA document created by the agency that sets forth criteria just for determining negligible impact, which is an undefined term in MMPA, is equally as long. Although well-intended at the time it was enacted, MMPA's ambiguous, outdated, and unclear language has proven unworkable. And in Wyoming, everyone is directly impacted by the ESA. Wyoming has 20 ESA-listed species. And while we all know about the grizzly bear, there are other listed species in Wyoming, such as the Preble's meadow jumping mouse, whose listing has proven both scientifically and politically controversial. Strangely enough, the only way to determine if a mouse is a, quote, Preble's meadow jumping mouse is to kill it and measure its skull. ESA compliance thus requires killing of the very species that the Fish and Wildlife Service is trying to protect. That's how far off the rails the ESA has become. For decades, stakeholders in Wyoming and Colorado have advocated for the delisting of the Preble's meadow jumping mouse, arguing that it is not a valid subspecies, and this is not uncommon. An alarming number of species are listed under the ESA but do not have what the public would describe as the best available science backing up those decisions. Even species that warrant downlisting or delisting are often caught in a never-ending loop of bureaucracy and litigation. Species like the razorback sucker, a fish that the U.S. Fish and Wildlife Service proposed to downlist in 2021, yet they have never finalized that action. Or the Greater Yellowstone Ecosystem grizzly bear, which has been listed as threatened since 1975. Its original recovery goal for Wyoming was set at 500 bears. Today, the population has more than doubled to 1,100 bears, far exceeding recovery benchmarks. In fact, the Greater Yellowstone Ecosystem grizzly population has exceeded recovery goals for over 2 decades. And despite this success on their way out the door, the Biden administration further delayed delisting of this species. There is no denying that after half a century, both laws need improvement, and the committee intends to do just that. Changes to the statutes will significantly improve the regulatory process for both federal regulators and the regulated community. And with that, I want to take the time to thank our witnesses for being here today. And I look forward to a robust conversation. Offshore wind farms, or the impact of offshore wind farms on the North Atlantic right whale has been well documented, yet politics prevents the Fish and Wildlife Service from acknowledging that, and instead they are misdirecting assets and resources towards going after things such as our fishing industry. And I think that that epitomizes one of the primary problems with the ESA and the MMPA. Mr. Vecchione, in your testimony, you state that the shifting legal landscape of the last 2 years, culminating in Loper Bright Relentless, now means that Congress can reassert itself. Loper Bright is thus an administrative decision, and it is not a policy decision. What does that mean for Congress going forward?
It means that you can't rely on a friend in the White House to fix a lot of problems by just changing the regulation. If you see a problem, Congress now has to address it. They can't, Paul, I say that one of the lawyers arguing this case told the court that sometimes Congress, it's divided in two. If they think the guy in the White House is of their own party, they don't want to do anything because they'll just get the right outcome. And then if he's in the other party, they'll fight whatever anyone's doing. Now, Congress, if it sees a problem, is going to have to address it because there's a very good chance, particularly when new things come along, that the courts won't allow the agencies to say this new thing is just like the old thing and to regulate it. So that's in a nutshell what I think is going on.
Well, I think that as practitioners, we need to be better at our job. I think that we as members of Congress need to do more in terms of providing definitions, perhaps putting preambles on our acts, but we need to be writing legislation that is not vague and ambiguous so that we don't need to worry about the courts interpreting or reinterpreting what we intend to do. Mr. Weiland, when the services are performing a Section 7 consultation under the ESA, is it ever appropriate for them to pretend that an existing structure such as a dam does not exist?
The short answer, Chair, is no, it is not. But I will say it's more complicated under the consultation provisions as they've been interpreted in the Act. The purpose of consultation is to analyze the effects of the proposed action on the listed species and if there's designated critical habitat on its habitat. But that requires differentiation between the environmental baseline for the species and the proposed action. So you have to look at what are the impacts from the action of the species and separately, what is the environmental baseline. And the existence of the dam, for example, should be in the baseline and should not be considered part of the action. And so someone who's changing operations of the dam, for example, should not have to account for the presence of the dam during the consultation. That should be in the baseline. In addition, I would say the pre-consultation operations, let's say you're getting a FERC relicensing, the pre-consultation operations should also be in the baseline. So you have the dam, you're operating a certain way, and what you're consulting on is your change to the operations. And that's the extent of the effects of the action as I see it. But I will say, in the case law and agency interpretation, these things are not as clear and there are divergent views about this issue. And as a consequence of that, there are many baseline activities that get captured up in the effects of the action. And the consequence of that is there are more jeopardy determinations that there need to be, and there are more requirements for minimization and mitigation based upon these baseline effects rather than the effects of the action.
Well, in fact, the past administration, they were notorious for failing, for trying to exclude these structures like dams in the baseline, and therefore they were restricting more projects and limiting more projects and finding more jeopardy. And I think that that is a problem, and I've experienced it for years working on the Platte River program as an example, where they literally ignored the dams that existed as part of the baseline and thereby creating problems of trying to put together a program for the endangered and threatened species. Again, Mr. Weiland, another question. The MMPA authorization standards require the government to find that an action will have a, quote, negligible impact and effect on small numbers of a species or stock. What does the small number standard really achieve?
There's very little in the legislative history about that I'm aware of. And so I would say because of the negligible impact standard, the addition of small numbers to that seems arguably redundant. And I would go back to comments that have already been made by my colleagues and by members of this committee. When all of these acts were passed in the 70s, it was contemplated there would be regular reauthorization. Same with the Clean Air Act and Clean Water Act, and same with these others. And during that period and into the 80s, there was of a number of these acts, and there were significant changes, for example, the Endangered Species Act in 1982. And that has essentially halted, and as a consequence, we are left with acts that are really being interpreted by agency and by judges, rather than Congress going in and being able to revisit and clean those up. And I think it's unfair to fault Congress in the 70s. It was doing the best it could. But if you were to go to a doctor and they were to say, I'm going to give you the same advice I would have given you in the 70s, you'd go to another doctor, right? And so if Congress can update the act, we'll all be better off for it.
I think that that's excellent advice. And with that, my 5 minutes are expired.